Good afternoon. This is Katie Ilten and Briar Andrsen this Valentine's Eve, here to talk to you about HIPAA. And, what couldn't be closer to your heart than HIPAA? We are here to talk to you about the large omnibus rule that came out a few weeks ago. We're going to give you sort of as specific as we can in an hour, but an overview of all of the, we think, significant changes and issues in the new rule. For questions, just a few housekeeping things before we get started. In the bottom, I think, right-hand corner of your screen, there is a field where you can type in questions. So as you're listening and you have questions, go ahead and type in. Our helpful IT people here will print those out, and we will try to get to them at the end of the web. Also, you will receive a survey form at the end of this, and we always ask you to fill out the survey forms, but in particular, we ask you to pay special attention to filling out this one, because what we are proposing to do, if I can advance the slide. Oh. Sorry, a little technical difficulties here already. There we go. So if on the second bullet point, we are letting you know that in July, we're going to do a follow-up to this HIPAA webinar. You will learn in a few minutes that the effective compliance date for these rules is in September. And so we've decided to just put on the calendar a date, and we're going to invite you all to come back. And once we've processed all of this stuff and figured out where everyone is and what people need, we're going to go through the nuts and bolts checklist of what you should be doing in order to get ready for that September 23rd, 2013 compliance date. In other news, our next month's webinar is going to be on RAC audits, how to respond to them, how to handle them, some creative arguments that you can make, some of the hot issues that are coming up with RACs. And that will feature David Glazer and a couple members of the group. David is a little RAC fighting machine, and he has lots of really interesting arguments. And this is happening to a lot of people, so we hope you will join us. And then finally, we'll say that as Briar and I work through these new rules and learn them along with you, we are always here to help you update your business associate agreements to the extent we think that's necessary, help you with questions on your notice of privacy practices, your policies and procedures, because we think particularly the privacy practices and the policies will need more updating based on this new rule. So you can call us or email us, and we are happy to help out.
Okay, and this is Briar Andrsen, and I'm going to take care of some of the beginning parts and the overview. And I have been talking about HIPAA since at least 2002, I think, and I'm recalling today one of our earlier seminars on this. One of the pieces of feedback that we got afterwards was, your lady attorneys talk too fast. So I'm going to try to go through this as quickly as I can and try and make as much sense as I can to cover. So if any is confusing or if you can't understand me talking too fast, please write a note and we'll try to address that.
And another reason to tune in July.
That's right. So as you know, there are a lot of changes that are happening because of this omnibus rule that came, but there really isn't that much that is truly new. Most of the things that were in this rule were developed because of or in response to the HITECH Act, and a lot of the stuff was found in the proposed rules that have been out since July of 2010. So people have been kind of knowing about this stuff and talking about it for a while, and now we finally have OCR's real true position on it. So we'll talk about enforcement, which is getting to be a bigger deal, but hopefully won't directly affect you. The security rule, which is, I'm not going to say too much about that other than that you really do need attention to it and do what the rule requires and has always required. And that includes those of you out there who are business associates, because OCR has been clear that business associates need to pay attention to the security rule and do the security risk assessment and all the other things that the rule requires. Business associate issues, a bunch of them that we'll talk about. Fundraising and the sale of PHI and marketing are big issues that are not important to some people, but are extremely, extremely important to others. Patients' rights, which affects all covered entities and all business associates. And then just a reminder, as always, state laws might be more restrictive than HIPAA, and when they protect patient information more than HIPAA does, you have to follow the state law. So always know what your state law says about whatever issue is going on. So the bottom line here is you should care about the new stuff, but you should not be freaking out. Or if you need to freak out, only just a little. The acronyms that we see here, just for your reference, we'll use these throughout the slides and you'll see them in other documents. Important dates, the rules came out January 25th of 2013, the final rule. The effective date is March 26th, 2013, and that date is not really very significant at all. The one you need to care about is September 23rd, 2013, which is the compliance date. That's when you're expected to be in compliance, whether you're a covered entity or a business associate. The one important piece of this, well, it applies as well. There's a transition period for a couple of other things too, but the big one is for updated business associate agreements and data use agreements that were in effect as of the publication date, January 25th, 2013, those don't have to be updated until September 22, 2014. So you've got some time with your business associate agreements, but you'll want to get on those pretty quickly. Enforcement is becoming a bigger issue. We have seen an uptick in both enforcements and investigations. The investigations that we're seeing from OCR are more detailed than they used to be. So now when you get a letter from OCR saying they have discovered that there is a potential issue, it's potentially a bigger problem than it used to be, and it might take you longer to respond, and you might be a little bit more worried about whether it's going to result in a fine. The new rule says that now the secretary may resolve indicated violations by informal means, not that they must. Basically, this means if they wanted to, OCR could jump right to civil monetary penalties, though we have not seen that happen yet, and I would be surprised if that did happen. So the civil monetary penalties in the new rule, I am not going to go through those in any detail. There are 4 tiers of them. Depending on how bad you were, they increase in amounts from $100 per violation to $50,000 per violation, and up to $1.5 million for violations of identical provisions in a calendar year. Again, hopefully you won't be seeing these and they won't ever be important to you. But one issue to consider is that there are agency issues for subcontractors, for business associates. So a covered entity is now going to be liable for civil monetary penalties for the actions of its agent when acting within the scope of the agency. And that is based on federal common law. It's a confusing standard, and OCR, I think, has not been very clear on it. But the key, I think, is you want to sort of act like all of your business associates are your agents. And kind of get the appropriate measures in your business associate agreement to protect yourself if you're a covered entity, and even if you're a business associate that uses subcontractors, to protect yourself on that end too. So as far as what sort of enforcement actions we have seen, really there hasn't been much in the way of civil monetary penalties. I think, Katie, there's only been one true civil monetary penalty, possibly 2.
Yeah.
But otherwise, it's mostly these, what they are calling resolution amounts, that go along with the correct action plan. And there have been a lot more of these, and they have ranged from $50,000 for hospice with a stolen to $1.7 million for the Alaska DHHS. They had a stolen USB, and they had inadequate policies and no risk analysis and no risk management and no training and other security rule problems. So that's where we're really seeing a lot of trouble, is losing electronic media and not having the appropriate security rule measures in place. So that is my biggest piece of advice, I think, would be to check what you've got right now and get yourself in shape on security and protecting the PHI that you have. Affirmative defenses is not a real big deal, but OCR has said there's going to be no civil monetary penalty if you establish that a violation is not due to willful neglect and it was corrected within 30 days. This is going to be really fact-specific. So basically, if you have a problem, something happens, try and fix it as soon as possible. You may or may not be eligible for the affirmative defense, and you may get out of a civil monetary penalty only to find yourself with a resolution amount, but it's still going to benefit you to get that taken care of. On to business associates. The new rule includes a revised definition of what a business associate is. It now specifically includes health information organizations, e-prescribing gateways, other providers of data transmission services to a covered entity, if that requires access on a routine basis to PHI. A business associate is also somebody that offers a personal health record to patients on behalf of a covered entity. And the big thing is that there's a change to the definition. It used to say a business associate creates, receives, or transmits PHI on behalf of a covered entity. Now it includes the word maintains. So you can be a business associate even if the entity does not view the information. OCR has said it's based on the transient versus persistent nature of the opportunity to view the PHI. So that, to me, is kind of a crazy standard. But this has resulted in them saying that document storage companies are business associates, even if they do not view the PHI that they're holding on behalf of a covered entity. And in the preamble language, they have said that shredding companies are also business associates. These, to me, they're new as far as I can tell, and seemingly inconsistent with previous guidance from OCR that said if you are doing something on behalf of the covered entity that requires PHI to do what you're doing, then you're a business associate. But this is pretty broad. So this, I think, will require covered entities to get business associates in place with companies that they wouldn't otherwise have done. The new rules say explicitly that there is direct liability for business associates, and a person is not a business associate by contract. It's by definition. It's what they are doing for the covered entity. So if some entity says, oh yeah, we're not going to sign a business associate agreement, we do not need to get our mitts on that, OCR would say, oh, well, sorry, the services that you're doing cause you to be a business associate, and your failure to have a business associate agreement in place is its own violation of HIPAA. So OCR has said any privacy rule limitation on how the covered entity can use or disclose PHI automatically extends to business associates. So this list of stuff, these are the things that a business associate has direct liability for failing to do. Subcontractors, business associates sometimes have other people helping them do their stuff. OCR has been clear you cannot let a subcontractor do something that the business associate can't do. So, for example, if the business associate doesn't have the right to de-identify information under the terms of the business associate agreement, then the subcontractor doesn't either. And someone to whom the business associate has delegated a function or activity or service has agreed to perform that for a covered entity or a business associate. That's a subcontractor that's going to need to have its own business associate agreement with the business associate. OCR has said each agreement in the chain from covered entity down to business associate, down to subcontractor, down to the subcontractor's subcontractor, each one of these has to be as stringent or more stringent as the agreement with respect to permissible uses and disclosures. So this, I think, kind of gets into a very tricky area because if a business associate signs something and a covered entity has required the business associate to be very stringent in some particular area, the business associate then must make sure that all of its business associate agreements have those restrictions. And this wouldn't be such a big deal if every business associate signed subcontractor agreements after it already had the covered entity business associate agreement in place, but that's not, of course, how it works. So I think this is going to be a little bit of a contracting nightmare and is going to be something that both covered entities and business associates need to think about, and is going to make it more important to be clear when you are negotiating business associate agreements about what you need to have, whether you're a business associate or a covered entity. The minimum necessary standards apply to business associates. You have to limit the amount of PHI being disclosed consistent with the covered entity's minimum necessary policies and procedures. So covered entities may be asked a lot to share their policies and procedures with business associates. The business associate agreement may or may not include specific provisions about minimum necessary, but OCR has promised future guidance in the area of minimum necessary, and so we hope to see that. But for now, try to limit the information that the business associate gets to the information they absolutely need to do their job. Business associate agreements, there is a sample BAA on the OCR website. It's not required that you use this, and it has to be amended to reflect your actual agreements between the business associate and the covered entity, or the business associate and a subcontractor. And OCR provides several options. We'll have a much, much better version of a template for you to use. I mentioned the transition provisions. You can continue to operate under your old contracts for up to a year beyond the compliance date, so September 22, 2014. If you have a business associate agreement that renews between March 26th and September 23rd, you should get a new one in place when the old one expires. Hopefully you don't have very many business associate agreements that renew in that way. Business associates should generally just be evergreen agreements that keep going until the relationship between the parties is over and the PHI has been returned. So have new business associate agreements ready to go by March 26th for anybody that becomes a new business associate. But you don't have to get the ones you already have done in place done before September 22, 2014. So some practical tips on business associate agreements. Make sure you have one in place. And if you don't have one, get one. And so this would be a good time to go through your list of entities to whom you share PHI and make sure that there is a business associate agreement there. Also review what information can be accessed by the business associate. You want to make sure they're only getting the minimum necessary amount of information to do their job. You don't want to be sending them a patient's entire record if they only need a piece of it or the payment piece of it to do their job. And indemnification provisions. We will definitely have an indemnification provision in our template document, and we've recommended those for a long time. Covered entities should insist on those because there is a lot of liability for a covered entity in dealing with breaches of the business associate agreement and breaches as that term is specifically defined, and we'll talk about that later. But the cost can be huge when there's a breach, and not just civil monetary penalties, but the cost of investigation and mitigation can be really big. So covered entities and business associates need to make sure that anybody doing services on their behalf indemnifies them for what they're doing.
I would just say one example of the cost that we've seen a lot is having to hire an outside identity theft company that is very expensive and very helpful because you don't have to deal with all of these questions about what happened to people's financial information, but it can be very costly. So that's one concrete example of a cost.
Right. And I should, related to that is, so often these are lost laptops, lost USB drives, that type of thing. Costs of forensic recreation of that information, so you can even figure out whose information you're talking about. That is another gigantic cost that you don't want to be on the hook for if it wasn't your fault.
Right. Okay, so I know we have a lot to cover, and I know we're going quickly. Be aware that you will get a CD with the audio of this webinar in case you're trying to take notes and it's going quickly. And we'll do a follow-up, and we'll do our best to answer your questions, whether that's during this time or after for follow-up. So my little section of this webinar is just to give you sort of an overview, is basically about those buckets of activities for which HIPAA requires a covered entity to have a valid authorization from an individual in order to use or disclose PHI for those purposes. So that's sort of the broad overview. We're talking about what sorts of things you need to have before you need to have an authorization before you do some of these things, and when you have an exception to that rule. So just to remind you, I won't go into the details of what is a valid authorization because hasn't changed. The next few slides list what is required for an authorization in order to make it valid. So I'm not going to go through those in detail, but this is just there to remind you of what you need once you determine that you need an authorization. So let's start with marketing. Marketing is the first sort of bucket of uses and disclosures for which HIPAA says you actually need an individual to authorize the covered entity to use or disclose PHI for marketing. I'm sorry to say that the explanation of what is or is not marketing has not exactly gotten easier, but I'm going to try to walk you through it carefully. So let's start with the broad definition of marketing. Marketing is any communication about a product or service that encourages the person who receives the communication to purchase or to use the product or service. So really broad definition, could include a lot of things. The devil's in the details of what the exceptions are to this requirement. So just remember that the general rule is that if you are marketing, then you do need an authorization from the individual. So first exception that's been carved out would be any communication that's made for treatment purposes by a healthcare provider, and that can include case management, care coordination, or any sort of direction or recommendation of alternate treatments, therapies, other providers, settings of care, options that the individual has available to them in their treatment. So that will be excluded from the definition of marketing, and therefore you will not need an individual authorization. However, there's a caveat, and I'll go into this in more detail later. If the covered entity is receiving payment in exchange for making that communication, then you will need an authorization from the individual. Another exception to marketing would be where, for example, a health plan describes a particular product that's now available in their plan of benefits or policy to an individual under the policy. And again, that is going to be excluded from marketing. The plan does not need an individual authorization unless they receive some sort of payment in exchange for making that communication. So what are we talking about when we get payment for making marketing communications? We're going to refer to those as subsidized communications. And what it is when a covered entity or business associate receives some sort of financial remuneration, and that does not include in-kind, like free computers or something. It's actual cash or financial payment from a third party, and the purpose of that payment is to make a communication about a product or service to the recipient. So if that is the case, even if you're under that, even if you're a healthcare provider providing treatment alternatives, if you're getting paid by a third party to make that communication, then that is going to fall back under the definition of marketing, and you will need a valid authorization from the individual who's getting that communication. Now, just to make things a little bit more confusing, there's a small carve out to that group of subsidized communications that are considered marketing. OCR has said in this final rule that if a covered entity is giving something like a refill reminder or otherwise communicating with a patient about a drug regimen, something that they're currently using under prescription, and maybe they're giving information about generics, there's information about particular products in the delivery system like an insulin pump, those communications by a covered entity to an individual, even if there is some sort of financial payment to the covered entity for making that communication, are not going to be marketing so long as the payment is reasonably related to the cost of making the communication. So let's take a concrete example. So say a drug manufacturer is proposed to pay a pharmacy, who's a covered entity, to send out by letter refill reminders to individuals that are taking a particular drug, or to send out information about maybe a generic that the manufacturer has available. And the payment in that case to the pharmacy to do that would be okay in that the pharmacy would not have to get individual authorizations so long as the payment was related to their costs in actually making the communication. So long as the drug company was saying, okay, we'll pay for your printing costs, your mailing costs, and those sort of reasonable costs. That's not going to be a situation where that pharmacy would have to go out and get individual authorizations. Now, change the facts a little bit. If the drug manufacturer was paying the pharmacy like an incentive payment, like we'll give you $10,000 if you send out 20,000 reminders, or if you get 10% of your people to refill their prescriptions with our drug, then we'll give you a bonus or something. In that case, the payment is not reasonably related to the cost of the marketing, and so that would be marketing, and you would need an authorization. And there are still these two carve-outs to communications that are considered marketing, but where HIPAA still does not require an authorization. So even if you're getting paid to make a communication, if the communication is face-to-face, you do not have to worry about getting an authorization. So we're talking about, when we're worried about authorizations, we're talking about non-face-to-face communications. And then, as always, is this small exception for giving promotional gifts of nominal value. So I don't know, maybe like a free plant or something, very minor. In that case, no authorization is required, even if you're getting paid to make that communication. So what do we do with all of this? If you do a lot of marketing, it would be good to sit down and map out whether you're getting paid for the marketing, and if so, whether there's an exception for these sort of refill reminders or communications about a prescription regimen that a patient is involved in. One thing that you can now take out of your notice of privacy practices is the statement that the covered entity can contact individuals to provide appointment reminders. OCR said that's kind of redundant at this point. If they get paid more than reasonable cost, they're going to have to get an authorization, and so that doesn't have to be in your notice of privacy practices anymore. If you have a business associate that does marketing or receives payment for marketing on your behalf, it would be, although you don't have to have more specific provisions in your business associate agreement about marketing, it might be important to make sure the business associate is aware of what they can or can't do with regard to marketing communications before or after they receive an individual authorization. This goes in the bucket of making changes to your authorizations. If you determine that you are doing marketing and you need an authorization, the authorization has to specifically say that the covered entity is going to get payment for that communication. OCR has also said that you don't have to have one authorization for every single communication that might be marketing. You can have a broader authorization, like the patient could consent to receiving marketing communications about programs to help prevent osteoporosis, or the patient can consent to receiving marketing communications about maybe from a particular vendor of the covered entity. So you don't have to have a single authorization for every single communication, and you might want to think strategically about how you want to group those and get the authorization from the individual. Okay, moving along quickly. The new rules, there's a new general rule under these new HIPAA rules, and that is that a covered entity now has to have a valid authorization before they sell PHI, disclose PHI and sell it to another person. And like the marketing authorization, the authorization for sale has to say that the covered entity is going to get payment as a result of the disclosure. So the devil's in the details as to what exactly is a sale. It's defined as a disclosure of PHI by a covered entity where they receive remuneration, which can include in-kind benefits. So if you get free computers from somebody for selling PHI, that's a sale and you would need an authorization. Now, importantly, the payment to the covered entity has to be, the purpose of it has to be to get PHI. So this wouldn't include interactions where the covered entity is providing PHI as sort of a byproduct of the service it's providing. So, for example, if you have a sponsoring educational institution that's paying a hospital to conduct a research study, that would not be a sale of PHI, even if the research results have PHI in them and the sponsor gets them, because the payment was not for the PHI, it was rather for the study. Another example that OCR has said is specifically not a sale is where a covered entity exchanges PHI through a health information exchange, and that's paid for based on a fee that each participant pays. In that case, the payment is actually for the services provided by the health information exchange to administer the database and not for the data itself. So as health information exchanges become more popular, it's good to know that those are not going to be considered sales for which we need individual authorizations. There are a number of exceptions to what is a sale. Most of these are pretty obvious. I won't go through them in detail, but if you have to provide PHI for public health purposes, when you're required to by law, when you're providing PHI and you're getting paid for treatment, that's not going to be a sale. Notably, they included in the exceptions to sale the situation where you're involved in a merger or transaction where you're selling part of the covered entity, and OCR said that's an exception. We're not going to treat that as a sale. We don't need an authorization. Some more exceptions include where the covered entity is paying a business associate for some sort of service the business associate is providing, so long as the payment is only from this covered entity, the business associate, or between the business associate and the subcontractor for activities that they're engaged to provide. Those are not going to be sales either. There is this interesting exception to sales for research purposes. So basically how this works is for an outside researcher, if an outside researcher pays a covered entity for PHI that they're going to use for research purposes, and the payment is reasonably related and is based on the cost of the covered entity to prepare and transmit the PHI, even though the covered entity is getting payment, that is not going to be a sale, and so you would not need an authorization from individuals for research purposes. And then any other instance where the covered entity is making a disclosure under the privacy rule, they're permitted to do it, and they get some sort of fee to cover their costs in actually transmitting the PHI, those are not going to be considered sales where they would otherwise need to get an authorization. For research studies that are in effect prior to the compliance date, where an IRB or a privacy board has said you don't need an authorization, and the payment to the covered entity for the PHI is more than what's reasonably related to the cost of providing it, those are going to be grandfathered in, so not to worry about those. And then I think we're going to see a lot of talk and further guidance about how in the world you figure out whether a researcher is paying you a reasonable cost-based fee for transmitting PHI versus a payment that would otherwise make the PHI a sale. Okay, so now we're going to get into a little topic that's sort of confusing about authorizations, and that's when you can have a compound authorization. So we'll start with the premise that the general rule is you cannot combine authorizations like the ones we've been talking about with any other document. They have to be standalone. And people have said, well, this is sort of a big pain, particularly in the research context. And so there are a few exceptions to this rule. The first is for unconditioned authorization. So you might be wondering, what the heck is a conditioned authorization and what's an unconditioned authorization? Well, an example of a conditioned authorization would be, for example, in research context where somebody, a patient wants to enroll in a research study, and the covered entity might say, well, fine, but we would need you to sign this authorization. We need to use your PHI that we gained from the research, and you can only enroll in the study if you agree to it. So that's an example of a conditioned authorization. And unconditioned authorizations are much more common. For example, you cannot condition you cannot condition treatment on getting an authorization from an individual for marketing purposes or for sale purposes. So those would be examples of unconditioned authorizations, and now it is the case that you can combine any two or more of those into one document. So if you want to kind of kill all birds with one stone and you want to have one authorization for your marketing and for your sale purposes, then you can put those together. One exception would be for psychotherapy, which I'll get to shortly. For research purposes, you can now have more than one authorization in one document. For example, you might want to combine it with an authorization or a consent to participate in research, so the person who's participating in the study doesn't have to fill out 500 forms. That's really what's driving these exceptions. And notably, a covered entity can now put a conditioned authorization, like the one where the treatment is conditioned on providing the authorization, with an unconditioned authorization, which might be, for example, an individual says, well, you can use my information for future research. Those can be combined now. Which brings me to the other point that HIPAA used to say, or OCR's interpretation used to be that if an individual authorized disclosure for research, it was only with regard to that study. And now they've become a little looser, and now individuals can say, I authorize disclosure for research with regard to this study and maybe future studies on a particular issue or that might be done going forward. And just the point here is that you have to make sure that when the person is signing the authorization, they know what they're signing and they know what their information could be used for in the future. And then for psychotherapy, I actually am struggling with coming up with a good example of two authorizations that you would combine for psychotherapy purposes. But I guess the point is, if you're combining an authorization for psychotherapy, it can only be combined with another authorization for psychotherapy. So that's a little weird exception. So stepping back from this compound unconditioned authorization thing, basically, if you are a covered entity that requests authorizations for research purposes, for marketing, for sale, if you're active in those areas and you want to combine them, tread carefully because you can do that now, but there are certain exceptions. And have your lawyer look at them over because it's easy to misstep here. All right, fundraising, I'm going to go through as quickly as I can because Briar has a lot of good things to say.
They're not that great, really.
So fundraising is, again, another place where you might need an authorization if you don't follow certain requirements. So fundraising is covered entities or their foundation or some business associate working on behalf of them is saying, we're going to raise funds for us, so we want to use information to send people letters to get their money. The general rule is that so long as you follow a couple things that I'll talk about, you can use the information on this slide for fundraising purposes. And so just to note a few things here, we've added to the type of information that you can use for fundraising Department of Service information. So now you can say, oh, these people were, underwent radiation therapy. That might be useful to figure out who would want to know about maybe another cancer treatment gala or program that they want to raise money for. So you can use that more specific information about outcomes and also what kind of treatment they received at the covered entity in order to make those fundraising communications. So here's what you have to do in order to make the communications without getting an authorization. You have to change your notice of privacy practices to include a statement that says the covered entity may contact the individual to raise funds, and most importantly, the individual has to know that they can opt out of the fundraising communications. Also, you can't condition treatment on their choice of whether or not to receive fundraising information. The opt-out piece basically has to be really obvious. It can't be kind of buried. If you're sending a letter, it can't be like buried in teeny tiny text at the bottom. The individual who gets the communication has to be able to say, whoa, I don't want this, and I know exactly how to get out of it. If you're hiring an outside telemarketer or phone service to call people, the person calling the individuals has to say you have an opportunity to opt out of future fundraising telephone calls. One question that came up with this is, well, before we even make our fundraising communications, once this new rule is in effect, do we have to send an opt-out notice? And the answer is no, so long as the first fundraising communication you make after the effective date of this rule the compliance date, makes it obvious how the person who receives that communication can get out of it. Also, the way to get out of it can't be really hard. It can't be a huge pain. You can't incur an undue burden. So OCR has said it would be an undue burden if you had to write a letter. If I'm getting the communication, I want to get out of it, and I have to write a letter, put it in an envelope, put a stamp on it, address it, and send it to the right person. That's too much. But you can maybe mail them with the fundraising communication a pre-printed, prepaid postcard that has them check a box and send it back. That wouldn't be too much. So basically, use your judgment, be reasonable, make it easy for people to know they can opt out and how to do it. And you can also say you can get back in. That's allowed. So takeaways for fundraising: revise your notice of privacy practices. If you use a business associate to fundraise, it'd be good to go through with them what to know about when they need an authorization and how to avoid getting an authorization and the opt-out pieces. Okay, I'm going to go through really quickly. Basically, HIPAA has said two things about patients who have died and their information. The first is that before the new rules, the covered entity had to protect that information to the same manner and the same extent as they're protecting patients or individuals who are living. And now they say, well, you only need to do that for 50 years after the date of death. And then going forward after that, we don't really care what you do with the information. The other more, I think, practical, helpful piece is that now a covered entity, and I would note that state law may limit this further, but HIPAA says that a covered entity can disclose reasonable information related to a deceased patient to a family member or to somebody who was involved in their care in order for the person to deal with the fact that this person has died. So maybe it's funeral arrangements, maybe it's payment after death for the services. Basically, you can provide information that's reasonable to someone that you think was involved in their care, unless you know that doing that would be against the deceased individual's wishes. Very quickly, student immunizations. I think this will be helpful, hopefully, for a lot of people. Under the old rule, you had to get a written authorization from a child's parent in order to share their immunization records with the school. Now you don't actually need written authorization, so long as you have agreement either over the phone or in person, and you documented that agreement. So the covered entity at that point they have evidence that they've documented agreement of the parent or the guardian, they can disclose the proof of immunization so long as that's actually required by the local law to the school in order to kind of move that along. I'm not going to spend really any time on genetic information because I think it mostly affects health plans. Basically, there are new rules about how genetic information can be used, and the general prohibition is that you can't use genetic information for underwriting purposes. So that's obviously going to affect health plans. You might see some language in the new rules about how you're defining health information. It now includes genetic information. I think it probably did before, but now that's very clear. All right.
Okay, so we do have a bunch of questions coming in, so I'm going to get through this next part, and then we'll get to as many of those as we can. I'm going to talk now about the patient's rights provisions that changed in the new rule, and these are part of the HITECH Act too, so these are probably not new to many of you, but they are now official. So patients have the right to request restrictions in general. They can say, I don't want so-and-so to have access to my information. And generally speaking, covered entities are required to allow them to ask, and then they don't have to agree to them if they don't make sense. But this right to request restriction must be followed by the covered entity. The person has a right to request restrictions of information made to a health plan if the patient is paying in full. So if they pay in full, they can say, I don't want you to tell Blue Cross about what happened, and you have to agree to that. That sounds relatively simple, but of course there are potentially huge problems. Health plan audits are a big one. Covered entities have to have some method to make sure that the PHI that is the subject of this request is not accidentally sent or made accessible to a plan for payment or healthcare operations purposes. Not clear at all how this will work in total cost of care situations or ACO situations, because it's just very difficult to keep track of which plans are getting access to which patient's information, and covered entities won't always have great control over that. So this, I think, is going to sort itself out. Luckily, I think we have not seen a lot of this happening. I don't think I've had any clients ask specifically about this. So it may be just either that patients are unaware of their right to ask for this, or they don't really care, or they're not willing to pay for things out of pocket. But for whatever reason, it's not happening a ton. There is an exception to this you may not tell requirement when the disclosure is required by law. For example, you might be required to disclose information for fraud purposes, or another similar reason, or in some cases you may be required by federal or state law to disclose for payment purposes. In that case, you don't have to. You're required to make the disclosure that's required by law. If patients don't pay when they say they're going to pay in full, you can bill their insurance, even if they've said they don't want you to tell the insurance company about it. As long as they don't pay, you can go ahead and try and get the money. You can ask patients to pay up front, and you can require prepayment if there's a pre-certification requirement that would otherwise not be met because you're not allowed to tell the plan about it. OCR has said for HMO patients, if you are prohibited by law from accepting payment from the individual that should be above the cost sharing amount, then you can tell the patient that he or she is going to have to use an out-of-network provider if they still want to restrict the disclosure to the HMO. But if the prohibition is only by contract, so if it's only the contract that says you're not allowed to charge the patients more than their copay, then that is too bad. OCR has said that covered entities still need to comply with the requested restriction. And if your contracts say that with the HMO, they say, well, take advantage of this lengthy 180-day compliance period to update your provider contracts to allow you to comply with these restriction requests. That one, if patients ever do start asking for it, I think that is a potential problem. Patients also now have a slightly different right of access to their information. The response time has been changed from 60 days to 30 days. So if a patient says, I want access to my info, you've got 30 days to do it. There is a one-time 30-day extension in sort of extenuating circumstances. And OCR has said generally would they encourage covered entities to disclose the information faster than that if they can, which they expect should be the case now that there are so many electronic health record systems out there that can do it instantaneously. If a person requests an electronic copy of PHI, that the covered entity has in a designated record set. The covered entity has to provide access in the electronic form or format requested by the person if it's readily producible. If it's not readily producible, then in some other readable electronic format as agreed between the covered entity and the individual. And that agreement could, if you've got a particularly prickly patient that is being a jerk about it, that making them agree to some format other than what they've requested could be somewhat tricky. And another potentially tricky part is if the EHR has links to images or other data, then those other images and data must also be included in the electronic copy that's provided to the individual. When somebody says, okay, I want my stuff, so here, put it on this USB drive, the covered entity may not want to allow that portable media. There are virus concerns and other security risks. So you could say, no, we're not going to do that. You can use one of our thumb drives instead, but you can't make the patient buy a thumb drive from you. If they say, yes, I insist on having it on this thumb drive, then you can say, okay, we'll give it to you, but it's going to cost you our cost of that. Then the patient can pay that. But they could also say, well, then I don't want it on a thumb drive. I want it in some other format, and you've got to work with the patient to get that taken care of. You can send an unencrypted email. That can be the form of electronic access that's agreed to, but you have to tell the individual of the risk of sending an unencrypted email, and the individual has to agree to still choose that method. If a person requests it, you have to transmit the copy, whatever they have requested access to, directly to another person designated by the individual. The request by the person has to be in writing, it has to be signed by the person, it has to clearly identify the person who's going to get it and where to send the copy of the PHI. So OCR has said this is distinct from an authorization, but to me it's not clear how. The form is distinct because an authorization has many requirements that have to be in there, many specific statements, it has to have an expiration date. It's a significant document. And so generally, it would be great if we didn't have to use authorizations, but I think they've been very confusing about this because if somebody says, well, clinic, I want you to send my information to my lawyer, and here's my piece of paper that has my name and my lawyer's name and the fact that I want you to email it, then the covered entity needs to comply with that. Normally, that would require an authorization, but I think now, because a patient's right to access their information is a specifically enumerated patient right, I think if you are hindering them from getting access to that information or getting access to their designated person, then that's a potential violation of HIPAA itself. So I think you need to be careful about when you say, sorry, we need an authorization for that, if they are trying to designate a third person for access. What can you charge patients? This has always been sort of a confusing area. And state law is definitely in play, and many states have specific requirements on this. HIPAA allows you to charge a reasonable cost-based fee. OCR says the state limits are, quote, relevant when you're determining whether a fee is reasonable, but if state law says that 25 cents a page is okay, but the cost to the covered entity is only 5 cents, you can't charge more than 5 cents. And that, I think, is a change for a lot of entities, or at least it's ignored by a lot of entities right now, and they're charging the state law maximum. OCR also permits charging for the labor costs of copying the PHI and getting it into electronic form, but they have said it is not okay to charge a retrieval fee. So what is the distinction there? I don't really know, but you should not label anything as a retrieval fee. And if a state allows you to charge $25 as a retrieval fee, you should be checking to see what your actual labor costs are to do that retrieval. Let's see, I think moving on to breaches, we've all been following along with the rules, the breach notification interim final rules, which have been in effect for a while. Basically, that rule says that if you mess up, lose PHI, if there's some significant harm to someone, you need to tell the person whose PHI it was, you need to tell OCR about it, and if the breach involves more than 500 people, you need to tell the media about it. So during this 180-day compliance period, pre-compliance period, the old interim rules are still in effect. But OCR has clarified now that an impermissible use or disclosure is presumed to be a breach unless the covered entity or the business associate can demonstrate that there's a low probability that the PHI has been compromised. And that is OCR said that was their position before, but they have really clarified it now. If you lose it, it's presumed to be a breach unless you can show that it isn't. And that notification is necessary unless that low probability is demonstrated. So in the new rule, a lot of things from the interim rule stayed the same, but one big change is there's no more significant harm standard. OCR thought that was too subjective, so they got rid of that, but you still need to do a risk assessment. It is not a case of if you lose PHI, it's automatically a breach. You do the risk assessment, which to me still seems like it's a de facto harm standard, but OCR says no, it is not. They've also removed the exception. They used to say that if you lost a limited data set that didn't have a date of birth and didn't have zip codes, then that's automatically not a breach. Now it's a potential breach, and so if you lose a limited data set, it requires you to do a risk assessment. Here are the elements of the risk assessment. You have to look at the nature and extent of the PHI involved, what kind of identifiers were there, who got the PHI, who used the PHI, whether it was actually acquired or viewed by anybody. And there they've said if you lose a laptop and then you find it and a forensic analysis shows that it was not ever actually viewed, that's probably not going to be a breach. I don't think that's a real big surprise to anybody. The extent to which the risk to the PHI has been mitigated and other factors where necessary. They've promised future guidance on this, and I'm not sure that it will be terribly helpful, but the upshot of this is that you need to really take a look at when you lose PHI, you need to carefully figure out, is this actually a problem? Has the PHI been compromised? And I'm making air quotes right now, but the term compromise has not been defined. Just a few scary things before we get to questions. OCR has said that PHI that is on devices such as photocopiers and fax machines and other similar devices is subject to the privacy and security rules, and they have said that covered entities and BAs have to ensure that PHI stored on these devices is appropriately protected and secured from inappropriate access, such as by monitoring or restricting physical access to a photocopier or fax machine that's used for copying or sending PHI. That, to me, is fairly crazy. That is, I think, a big change for a lot of entities that hadn't really paid attention to their copy machine, and probably everybody in the office has access to the copy machine, and unclear exactly how you would restrict physical access to that, but that's out there. They have also said that in many cases of breaches, there will be both an impermissible use and disclosure and a safeguards violation, so they're saying a security rule violation, and that they can calculate separate civil monetary penalties for those, so that's another way to up the risk a little bit. And then they have also said that demographic information, if it's tied to a covered entity, then it is PHI, since it indicates where the person received health care or benefits from the covered entity, and therefore it must be protected. They were specifically talking about business associates in that language, but it's a pretty strong position in general to say just the fact that somebody is a patient of a hospital, for example, that by itself is PHI. They have also said that violations of the minimum necessary standard might require breach notification. They're considering further guidance on that. So finally, here's our to-dos. Katie already mentioned several of these things. You need to update your notice of privacy practices. It has to include at least those changes that are mentioned there. Note that you don't have to hand out the revised notice to everybody. You just have to make it available. Although OCR has said you can't just have it and make somebody ask for it. You have to, for example, have it in a pile on the desk so a person can just grab it. Update your policies, update your business associate agreements, review your current agreements to see what's out there and who they're with. Do a risk assessment, train people on all of this stuff. You need to make sure that anybody who is having access to PHI knows what they're supposed to be doing with it. And then the last bullet point on there, encrypt all your electronic stuff. The security rule does not require encryption. It requires you to sort of think about it and decide whether it's worth it to do it, but it is worth it to do it. That is, if you lose a laptop that's been encrypted, it's not a breach. If you lose a laptop that is not encrypted, you are in trouble, and you're going to be facing costs and a lot more time and trouble than you wanted. So that's it. Now we'll try and get to a few of these questions.
All right.
And we can try and stick on a little longer than necessary to get to some of them.
Okay. So, very basic question that I probably should have covered. What's an example of when a covered entity would sell PHI? I think maybe the purest example of this, the most common that I've seen, is where like a vendor wants your mailing list for a group of people who've received a certain type of treatment, so they can mail them. They want to buy the mailing list, and then they want to mail the people information about what they sell. And so I think that's a pretty pure example of selling PHI, where the payment that the covered entity gets is in exchange for the PHI, and you would need to have a valid authorization.
One question, do we need a business associate agreement with our landlord if the records are stored in a separate suite from our clinical site? And I would say probably not. Before I would have said definitely not, but the OCR has sort of muddied the waters on that a little bit. But I would say if the landlord doesn't have access to the suite, or if they only have access upon prior notice, then they're probably not a business associate. If you're able to kind of keep that information confidential, then the landlord shouldn't have any right to get into it and probably would not be a business associate.
Okay, we got a couple different questions about emailing patients. And whether, in fact, we need to get authorization from patients to email them. So I think, Briar, the general rule is that if a patient has consented to receiving communication by email about their treatment or whatever, then you can email them back, right?
Right. I would say you don't need authorization. You just need for the patient to agree to it. And you should tell them, our email is not encrypted, or, if you want this, we're going to just send it via email. Is that still okay?
Yeah.
And document that they've said, yep, that's okay.
And then also following up on that is this question: we collect patient emails, which we use to send e-newsletters to patients. Are we required to obtain a written authorization from them before sending these marketing emails? So I think the question is, there are a couple sort of threshold questions. First, what's in the email? If it's indeed a communication about a recommended therapy or treatment that you might be encouraging someone to receive, but you aren't actually receiving payment for sending that email, that would fall under the exception to marketing. So if you're sending it out, it's about future treatment, it's for treatment purposes, and you're not getting paid by a third party to send it, then you're under the exception to marketing. But if for some reason you're getting paid to make that communication, then you would need an authorization from the individual where they would know that you're getting paid to do that.
Is a business associate violating HIPAA if the business associate does not enter into a business associate agreement with the covered entity? That's a good question. Unfortunately, I think this is the covered entity's problem. It would be the business associate's problem if they failed to get their own subcontractors to sign a business associate agreement, but directly between the BA and the covered entity, it is the covered entity's problem.
Okay. Here's a question about BAs and internal people. If we have a researcher who is an internal staff member, do they need to sign a BAA? So in this circumstance, I think since they are part of your workforce, they're an employee or part of your workforce, then they would not be considered a business associate, and so that you would not need a business associate agreement with that person.
Someone has asked, what about a specialist that doesn't have an EHR? This is a challenge without an EHR system. I'm not sure if this is a reference to providing information electronically. If it is, you only need to provide the information electronically if you have it electronically in your EHR system. You're not required to go out and create an electronic copy to give to patients.
Okay, here's kind of a good one. If physicians use patient data for a presentation that is given, is that considered marketing? Example, the patient has a particular condition and has been using a specific medication that has been successful in treating that condition. Can the data be used, or does the patient need to sign the consent? So it's interesting here because the marketing piece that we talked about is really about where someone gives an authorization to receive marketing communications. So I actually don't think we'd be talking about having to have an authorization for that person to receive the communication. But if the reason that the physician was using the information was not for treatment, payment, or healthcare operations or some other permitted purpose, then you would still need an authorization from that individual to use that information to do their own, for the physician to do his own marketing.
On the agency liability issue, is there a catch-22 in that the more oversight the covered entity provides to prevent incidents, the more the covered entity is potentially liable for the business associate behavior? I would say yes. That is a catch-22 for sure. And it puts covered entities in a very difficult position. But that is, I think, the big reason why you want an indemnification provision, because my thinking is you can either audit everybody up the yin-yang, or you can get an indemnification provision. And covered entities are in a terrible position to audit their business associates. So I would say get that indemnification as much as you can. Let's see here.
So it seems like a big takeaway, and I was going to say this earlier, and Briar mentioned it, but really important to remember is that if you take steps to have policies and to do risk assessments and to really train people, that is going to go a long way, we think, in terms of someone looking at you later based on a stolen laptop or something. It's going to turn out a lot better for you if you've actually done stuff before the bad thing happens. And in fact, it's the stuff that you did or didn't do before that might get you in more trouble than the bad thing.
Right. Question about, do we have to keep healthcare records for one patient separate if they pay in cash for one treatment and use insurance for another treatment? No, they explicitly said you don't have to create two separate healthcare records for one patient, but you do have to figure out a way to flag it. And there's some language about bundling and unbundling, and that providers need to let patients know about that, which I think almost no providers will actually be able to do. So that's a potential concern, and you need to try and figure out a way to flag the information, but you don't have to keep it totally separate. You don't have to create two records. Another one, what are the rules for faxing information to patients? There really isn't a specific rule on faxing. You can fax stuff. You should make sure that you're using the correct fax number, and you should, if you can, clarify with the patient ahead of time that they're, is this fax machine secure? If they say no, they say, do you mind if we still do it? Do we need to call first? Just try and clarify with them how the information is going to be sent and when.
Here's a question about what reps and warranties, if any, would you expect/demand from a business associate, like an IT vendor? So this is where it's important to be paying attention to maybe what the business associate is going to be doing for you. So if they're an IT vendor, I would certainly want to see representations and warranties that they'll be in compliance with all the security rule pieces that is required, and that would probably generally be part of the agreement, but you can certainly focus on things more specifically that you're worried about.
Yeah, and one thing that we've seen fairly often is requiring encryption, and that probably wouldn't be in a template document. But if you have an entity that is getting a substantial amount of information, requiring them to encrypt it is not a bad idea. Question about whether Fredrikson has a recommended risk assessment tool to use, and if so, how to get it. We don't really have a risk assessment tool. I think part of what we'll develop in our policies will, in the breach notification policy, there would be kind of information about how to conduct a risk assessment. But I'm not a huge fan of the risk assessment tools that I've seen so far, especially the ones that attach a number value to certain elements of the risk assessment and then come up with, if it's between 14 and 18, then it's a breach. I think it has to be a lot more subjective than that. So you can't just plug a situation into a tool and have it come out with the right answer. You really need to kind of sit down and think about it a little bit. But we can certainly talk further about that if you have questions.
Here's a question about if we operate clinics and surgery centers and use the same, I assume, EHR system, are there limitations to viewing and sharing information between the two? Is a separate authorization required even though technically it is the same company? So I think this is one situation where state law is going to make a difference. So, for example, in Minnesota, unless you're an affiliate, which is statutorily defined, you would need a consent in addition to HIPAA to disclose information outside of your entity. But just under HIPAA, if you're allowing people to exchange information between clinics and surgery centers for permitted purposes like treatment, healthcare operations, then you would not need a separate authorization to do that.
Question saying that someone is confused about the retrieval fee. How is that possible? So clear. The question is, can we charge $25 to a patient or to a third party, like an insurance company, for the cost of looking for their record, and if we find a record, providing it to them? You can't have a set retrieval fee. You're allowed to figure out what the costs are based on your labor of looking for it. And I don't think that they are expecting you to do this every single time. But you should be able to quantify how you're getting to whatever number you're getting to. You know, it took this person who is at this rate this amount of time, or takes them this amount of time to get it. But I think that OCR would have a problem if you were charging $25 to somebody when all that a person needed to do was go click on a button and print something out or email something. Another one on security surveillances and whether it's allowed in a mental health clinic. I assume this is asking whether it's okay to have a security surveillance system in a mental health clinic, so something where you're recording patients, and that should be fine. There really isn't any specific place in HIPAA that talks about that. You would, I think, need to be careful about who has access to those recordings and to the system. Think about how long it's kept and whether it's needed, that type of thing. But I don't think there's anything out there that's real specific that I'm aware of.
Here's a question. Is your copier vendor a business associate by virtue of data stored or maintained on the copier itself? And then I touched on that.
Yeah, I think yes, probably they are. Because they, more than anybody else, really have access to the information that's stored there. I would not personally know how to get information that's stored on a photocopier off of it, but the vendor does. And so I think probably erring on the side of being a little bit conservative about that, I would say they are a business associate.
Here's a question. Is a business associate agreement needed with our reference lab with whom we have a contract agreement? So it's important to remember that still in HIPAA is this exception to when someone is a business associate where two covered entities exchange information for treatment purposes. And so I think if you have a reference lab and you're providing information to them for treatment purposes, they would that would fall into this exception, and so they would not be considered a business associate.
Would lost medical records constitute a breach? For example, a hospital loses a hard copy of a patient's medical record. Probably. You would do a risk assessment on that, but unless unless it was lost in, if you lost it outside and some other hospital worker found it and it had only been 5 minutes after the person lost it and they determined that nobody had looked at it, then I would say, no, that's not a breach. But if you lose it and can't find it, then I think that is a breach. One of the resolution amounts that we have seen was a clinic where somebody left, I think, 100 or 150 records on a subway seat and then got off, and then they were gone forever, and they had a big fat fine for that, I think $1 million or $1.5 million or something like that. I think we can probably go for just a couple more minutes here, and then we'll let you guys go. Katie, do you have any here?
Here's I think this might be a follow-up on what someone asked for reps and warranties for business associates. We currently present an annual survey to our business associate vendors asking them if they've updated their policies, have a privacy officer, have had any incidents, etc. That's not a bad idea. A lot of people put in their business associates agreements the right for the covered entity to come in and audit them, and I don't really think many covered entities do that because it's a big pain and time suck, but it would be, you know more what was going on if you took the proactive step of just asking them to provide you with this information every year.
Yeah, and I think that's a good idea too, because it puts the business associates on notice that they actually need to be following this stuff, because I would say probably 70% of business associates ignore the requirements, or have in the past. Now that they've got direct liability, they might not. One technical question, can I get printouts of the webinar? It's not. You're having a hard time hearing us, so I apologize for that. We will have a recording of it, and it will be sent out to everybody, and at some point will be just streamed online on our website.
Yes, we're hoping that's coming in the next few months. And I believe we'll be putting some of the old webinars on for streaming as well. Okay, this is a good one. Briar might need your mind here. Would a covered entity need an authorization from its patients to conduct a marketing survey of its patients? So for example, the purpose of the survey is to allow the covered entity to assess the patient's level of satisfaction with its services. I actually don't think that would, well, even if it is marketing, if you're not getting paid to make that communication, then it would fall into the exception to marketing and you wouldn't need an authorization. I would think maybe that might just be healthcare operations.
Yeah, I think that's right. And you're not asking the person to buy anything or do anything. You're just asking for feedback. So I think that's not, I would say that's not marketing.
Probably not marketing, but as long as you're not getting paid, I wouldn't be too worried about it. In regards to electronic devices leaving the covered entity, such as an iPhone with a patient's schedule, is password protection and auto wipe feature sufficient? Well, I mean, I think those are reasonable. I think the safest thing to do is encrypt.
Yeah, there's OCR has a like a one-page document that's sort of full of bullet points about what you should do with mobile devices. And mobile devices are a big area of concern, and there's a lot of PHI floating around out there on unencrypted, doctor phones and just iPads everywhere. And so I think those things that you mentioned are sort of the things you should for sure have in place. But if you send us an email, we can send you a link to that OCR page, the mobile device page.
Okay, this person says, are these new rules simply final implementations of HITAC? And I think that they're asking, are we done now? And they are indeed implementations of the HITAC Act, which came out in 2009. And we hope that this is sort of the last swath of things, at least for a good few years.
Yeah, and they're not just implementation of HITAC, though OCR did take a couple of liberties and added a few other things that were not part of HITAC to provide more protection.
Okay, so this is, if our shredding company needs a BAA, are we expecting them to set up a privacy officer, security officer, HIPAA policies and procedures, et cetera? Is this realistic?
I would say it is a great question, and it is totally not realistic. And OCR said in the preamble to this final rule that they learned from the commenters that some of the smaller and less sophisticated business associates would not have the resources to do that. And they said, well, we have helpfully added an explanation of what we expect the cost to be to the final rule, and they can go to the OCR website and look at the OCR helpful hints on how to do that stuff. It is, I think, completely unrealistic, and the shredding company is going to say, what are you talking about? And so will some of your other business associates say that. And I think at some point you sort of have to say, okay, well, we can't be in control of what everybody does about this. They are directly liable, and we're going to just have to say, if they say that they are going to sign this business associate agreement that requires them to do these things, we have to accept that we don't have total control over whether they do, but hope that they do, which is not a great answer, but you can only do so much, and the business associates are going to have to take responsibility for themselves.
Well, I think we still have some questions coming in, and there are some that maybe we didn't quite understand the question. So we will actually, I think we'll just sign off now. Thank you for joining us. Check in July, and for those who weren't able to get to your questions, we will follow up afterwards.
And please do fill out the surveys and let us know what would be helpful to hear more about come July.
Thank you.
Thanks, everybody.